everybody. Uh, First of all, I would like to introduce myself. My name is Irma Rimawati from Pasundan University. In this special occasion, I would like to deliver my paper entitled "The Transformation from Fault Liability to Strict Liability: A Cutting-Edge Indonesian Maritime Tort Law" for Barbuda International Seminar. First, I would like to deliver the background of the study that the safety of shipping, the cause of pollution, become a serious issue and serious problem for our life nowadays. Since Indonesia is a archipelago states, are depend on export and import from international shipping. And especially for Indonesian case, ship transportation plays a crucial role in the framework of the interstate relation. Uh, Carrier liability in pollution prevention is a very complicated problem since the natural condition of Indonesian Sea located between two continents and two oceans. So we can say that Indonesian water are very dangerous for ship and uh, we have a lack of monitoring condition of the ship that result to many accidents that make a consequence not only for the goods and passengers but also to sea pollution. According to data from obtained from Ministry of Transportation of Indonesia, there were 548 ship accidents happen along between 2020 until 2023. And the problem statement in Indonesian law, a ship collision and pollution are unlawful act. So the theory of liability insurance said that pollutant must pay from environmental restoration. But in Indonesia, we still confused which liability can apply to the sea pollution and sea collusion, whether it is based on fault liability or strict liability. From the problem above, we some question some research question come up as follows. The first, what are the natural liabilities under Indonesian maritime law? And the second, how the liability apply to the Indonesian ship owner? The method, we have comparative law method approach for alternative by comparing the existing regulation, and the data come from the secondary data, and we have also the field research to support the secondary data, and the data come from interview questionnaires from Ford shipping companies, policymaker, and the library research, and all data are analyzed by descriptive method. And we can go on to the result of the research. For the first question, we can assume that the carrier as the owner of or operator must liable anything happen on their activity in good way, such as contract, in a bad way, such as unlawful act. And unlawful act in shipping activity is when his ship polluted to the ocean because of many casualties that create badly dangerous impact to the sea. And in maritime law term, the marine casualty caused by shipping known as marine casualty, and marine casualty are a burning ship and then sinking and wrecking ship, and then pollution for laid up ship, oil pollution from tanker ship. And for the second question, there are some liabilities regime in Indonesian law, namely full liability based on fault liability, based on fault negligent liability, unlimited or presumption liability, and strict liability. And for the regulation, we have many liability, such as for the commercial code, we have for liability, and for the Hague Fish Bureau, we have liability based on negligence, and the Shipping Act, we have a presumption liability. And for the collision, we have strict liability from CLC, and commercial code. We have a liability based on fault, and the Environment Act, we have a strict liability. But we can see that the strict liability is the shorter and the fastest principle who can make the one guilty or not. But we have some obstacle in applying strict liability. It is rarely used in court decision, and it has high consequences for the carrier, and polluter will deceive or cover up the fact. But Indonesia must apply strict liability because Indonesia has some obligation to comply with all international provision. Besides, the liability based on fault is harm for the state and more suitable in the case of pollution. And the last, it's good for the victim and even the polluter. But Indonesian ship with strict liability is very hard, and strict hardly for Indonesian ship because the due to the data or to the high value, and in Indonesian strict liability can be only implemented in sea pollution only. Sea Indonesian ship, the compensation must be bound by another form, namely mutual liability. As the civil liability, this liability forces company or ship to spend more monetary value. For this reason, the development of maritime law is not only related to the company but also the stakeholder. For helping the carrier in applying strict liability, mutual liability for business productivity and profitability. So the mutual liability is continual process involving collective responsibility. A mutual liability is a liability which contains a mutualism and brotherhood aspect. For carrier, mutual liability means when a carrier establishes a group based on mutual benefit. And for the stakeholder, mutual liability means that activities are done together, preventing collision and marine pollution between port state control, carrier, feeder agency, marine safety and security, and the pilot. And last but not least, we have some conclusion here. For the first, that there are some various liability form of the carrier liability in Indonesian maritime law, namely the full liability based on fault liability as regulated in Indonesian commercial code, and then the liability based on negligence as regulated in international convention, and strict liability as regulated in environmental act. And Indonesia must apply strict liability in environmental pollution cases while maintaining fault liability for other top case. This transformation is essential for aligning Indonesian maritime tort law with international standard and improving legal remedies effectiveness in marine and environmental pollution cases. That's all for my presentation. Thank you very much for your attention. I would be very happy to receive any suggestion, correction, and advices to enrich this research further. Goodbye.